don't know me, my name is Madeline Shelton, and I'm the Vice President of the Federalist Society here at UK Law. And for today's event, we have the distinct honor of hosting Professor Josh Blackman. Mr. Blackman is a professor and the Centennial Chair of Constitutional Law at South Texas College of Law, Houston. He is a national thought leader on constitutional law in the Supreme Court. For his expertise, Professor Blackman has testified before Congress, advises federal and state lawmakers, and regularly appears on news channels like NBC, ABC, Fox, and more. He's received numerous awards for his work and has had his scholarship published dozens of times. Before his legal career, Professor Blackman obtained his JD from the George Mason University School of Law. So everyone, please join me in welcoming today's speaker, Professor Josh Blackman.
You forgot. She forgot the most important point. I clerked in Kentucky for Judge Boggs in Sixth Circuit. So I love coming to Kentucky. It's like almost a second or third home. I very much like coming here. And you were such a gracious host, so thank you so much for having me. The Supreme Court. Lots to cover in a very short amount of time. Let's start with some numbers. Much is said about how divisive the Supreme Court is, how they don't agree on anything. And that is maybe true in a few cases, but not true in the big picture. So last year, just guess, how many cases were either unanimous or 8-1? You want to take a guess. What percentage? 5%? Any other number? Yeah. Half. Half of the cases last year were either unanimous or 8-1. I like this number to start because the court, for most cases, agrees. And agrees by a very lopsided majority. Okay. What percentage of cases were 6-3 with the 3 Democratic appointments in the minority? About 10%. So it's only a small percentage of the case that fall along these hard lines. What percentage of the case had 3 Republican appointees in dissent? The same, 10%. It's roughly the same number of cases had the 3 Democratic appointees in dissent as had 3 Republican appointees in dissent. All right. Who is the majority the most? Once again, Chief Justice Roberts. He is the center of the court. He's the majority 95% of the time. Okay, next question. Who's in the majority more often? Justice Elena Kagan or Justice Samuel Alito? The answer is Justice Kagan. Kagan was the majority about 80% of the time. And Justice Alito the majority 70% of the time. Indeed, Justice Sotomayor was the majority more than Justice Thomas. Justice Jackson was the majority the least, around 72% of the time. So without question, this is a conservative court. But it's not the conservative court that you might read about in the press. Who agrees the most? Justices Thomas and Alito agree 97% of the time. Roberts and Kavanaugh agree 91% of the time. Okay. Which circuit had the worst reversal rate? Where I think, oh, the Fifth Circuit, right? They get reversed all the time. Well, they got reversed about 80% of the time. But the Fourth Circuit went 0-8. They got reversed in every single case. Which justice speaks the most in the court? This one's not even close. It's Justice Jackson. She speaks more than 50% more than any of her colleagues. But Barrett speaks the fastest. She crams the most words in per minute, if you care about those sorts of things. All right. So I tried to divide the cases up into a couple different categories. The first one might be administrative law. How many of you taken admin law yet? Or will take it? Very important case. Most of the law that goes on today is not actually passed by Congress. It's developed by agencies. So there were a couple of cases I want to talk about. The first is a case I was involved with called Bondi versus Vanderstock. This was a case about ghost guns, and I use those scare quotes very deliberately. For the longest time, the rule was you could buy these gun kits, which had partially manufactured guns, and you could build them yourself. No background checks required. The Biden administration decided, well, these kits are basically guns, and we'll treat them as guns. I was one of the lawyers in this case. We won in the lower court. We won in the trial court. We won the Fifth Circuit. And they go to the Supreme Court. We lost 7-2, and really it was 8-1. The court held that because these kits can be readily converted to an actual firearm, they basically are firearms. The upshot of this case, though, is now a wide range of people will become felons if they still buy these gun kits, so now these are now more or less illegal. Okay. Let's talk now about transgender medicine. There was a very significant case called Skrmetti. It's a very hard name to pronounce. Skrmetti, Skrmetti is actually a person's name. He's a Tennessee Attorney General. So Tennessee and a number of states passed laws that ban what's known as gender-affirming care for minors. Adults can still access it, but not minors. There are different forms of this treatment. One approach is what's called a puberty blocker. These are basically drugs you take that prevent the onset of puberty for teens. The second is what's called cross-sex hormones. These are actually, for example, testosterone or estrogen that can actually give someone who's perhaps biologically male, female traits, give someone who's biologically female, male traits. For example, you grow hair, deeper voice, and so on. The third type of care is often called top or bottom surgery. These are actually pieces of surgery performed that make genitals look different or remove breasts and the like. Okay? Tennessee banned these three practices generally. I say generally, I'll come back to why in a moment. There's an exception. This goes to the courts. The Sixth Circuit upholds the law in its entirety. And there are two grounds on which they uphold it. The first involves what's called substantive due process, or the Due Process Clause. Parents in these cases argue that we have the right to direct the upbringing of our children. We have the right to seek the medical care that we want to have for our kids. You can't tell us what to do. And the court said, no, that's not right. You can protect your children, but if the state deems certain medical treatment to be harmful, they're allowed to ban it. And this was sort of in tension with some of the vaccine cases where parents didn't want to get their kids vaccinated, but they had to go to school. All right. That was a liberty argument. The second one was called equal protection. And the transgender advocates argue this is a form of sex discrimination. Why? If a person who's biologically male wants to take these drugs from a female, they can't. They said this is a form of sex discrimination. So the Sixth Circuit rejected that also. They said, no, this is not sex discrimination. And even if it is, it survives constitutional scrutiny. All right. The case goes to the Supreme Court, and the court splits 6-3. This is one of those cases that goes hard left-right, where Sotomayor, Kagan, and Jackson are in dissent, and the Chief Justice had the majority. Now, the Chief Justice's majority opinion is what I call a bit of a Houdini, where he does kind of like misdirection, kind of like magic, right? Never trust the chief. He's always doing other things. So Robert says, there is no sex discrimination here. Why? There's age discrimination. Oh, he's very clever, isn't he? Age discrimination. Why? Because if you're 18, you can get this treatment, but if you're 11 or 12 or 9, you can't get this treatment. Okay. We all know, for example, driver's licenses, right? In some states you can drive at 16, in some states you can drive at 17, in some states at 18, it varies by state. We generally think that age discrimination is what we call a non-suspect classification, reviewed with only a rational basis standard. Okay. The challenge, of course, is that puberty-blocking drugs generally only work during puberty, and if you're 18, you can't use them anymore. But the court sort of just pushed that argument aside. Roberts had a second argument that this was not just about age discrimination. It was also saying that certain medicine can be used for certain types of conditions. So let's say you are a 9-year-old boy and you're developing puberty already, or you're an 8-year-old girl, you're going through puberty. The law allows you to have puberty blockers if you want to stay a girl but not have puberty. But you can't use those same drugs to transition to a different sex. Roberts says, well, that's fine. The state has power to decide the use of medicine for certain purposes. There were several concurrences by Justice Barrett and Justice Alito that seemed a little bit dubious about the majority. And they basically said, well, maybe this is sex discrimination. Or maybe it is also discrimination on the basis of transgender status. I think those are probably the more accurate opinions. And they said, even if this is sex or discrimination or transgender discrimination, it's still constitutional. The state has an interest in keeping children safe, and the state determines this medical treatment is harmful to kids, they can ban it, period. So the majority opinion by Roberts sort of tap danced on the issue of whether this is sex discrimination or transgender discrimination, but this will come, excuse me, this will come back to the court this year in a case concerning athletics, whether transgender athletes can participate in female athletics. So this issue will come back. All right, let's go on to free speech. I always ask this question. Who has TikTok on their phone? What is wrong with you? You have a Chinese app on your phone. They know everything. Oh my goodness, you people. Anyway, so about, I'm mostly joking. China, don't listen. Right. Towards the end of the Biden administration, there was actually bipartisan legislation. Truly, there was. And this law, does this work? Oh, this is good because I'm yelling a little bit. So towards the end of the Biden administration, there was a law that basically said TikTok, you must divest from Chinese ownership or shut down. Okay? Everyone hear me? Better? Okay, that's much better. Thank you. So the law said like this. TikTok, you must sell to an American company or shut down. The law is to go into effect on what date? January 19th of 2025. The day before the inauguration. Okay. Immediately, a challenge was brought. TikTok argued this violates the First Amendment. And the case had to move quickly because the law is going to effect in January of 2025. The lower courts upheld it, and the Supreme Court affirmed unanimously. The court unanimously held that this was not a restriction of speech. Rather, this was a regulation of an American product that's used by a foreign adversary, right? That the United States government has interest in not having on all your phones a Chinese app. Okay, you, right? That the US government can say it's dangerous to have these apps on your phone. And the court upheld it. 9-0, my goodness, this wasn't even close. Then what happens on January 19th of 25? Well, after Joe Biden pardoned his son, some other things, he signed an order. And he said, we will not, maybe it was an auto pen, I'm not sure, but something signed it. And the order basically said, we will not enforce this law for the next 24 hours. In other words, for the last day of my presidency, I will not enforce this law. Again, the court upheld it. The court said this law is constitutional. But Biden said, or the auto pen said, I will not enforce it. So what happens when Trump comes the next day? Oh, Trump signed a lot more things, but he also signed an order saying, yeah, we're not going to enforce this law either. So you have this very weird situation where Congress passes a law, bipartisan, the Supreme Court upholds it 9-0, and then both Biden and Trump say, we will not enforce this law. And in fact, Trump went a step further. He said to TikTok and Verizon and AT&T, you have no liability for enforcing it. We will not take any action against you for enforcing this law. Go figure, right? So here we are, what's today, October 8th. The law still has not been enforced. Trump keeps issuing these orders saying we will not enforce it, we will not enforce it. Apparently there's some deal where TikTok will be purchased by Oracle, some other American companies. I don't really know, I don't actually care. But this is an area where the court upheld a massive law that arguably infringes free speech. No president wants to enforce it, and now we're just pretending the law doesn't exist. Okay. Let's go from TikTok to porn. Texas and other states passed a law that said only adults over the age of 18 can view pornography online. So if you are, one of these Pornhub, one of these other sites, you need to implement age verification software. Can the government do this? So there's a very old precedent going back more than half a century, which says, yes, the government can restrict the sale of adult magazines to kids. Do you know what an adult magazine is? Like a Playboy or Hustler or some sort of pornographic, material. But back in the day, what would happen? You go to a clerk, you show your ID, and then he would give you the magazine. The clerk wouldn't make a copy of your ID, he wouldn't write it down, it wouldn't be shared. Today, people worry that if they use some sort of age verification software, their information can be leaked. And, maybe people will be blackmailed. Like, I know what kind of pornography you're viewing. I can show this to your wife, and so on. So they're fearful of sharing their information online. Now again, they share their credit card numbers, so they got to pay for this stuff, right? But they don't want to share their driver's license information. Query how much of a difference there is. The issue in this case is what level of scrutiny would apply, right? Would this law be just a simple age discrimination, right? In which case you use rational basis standard like Scrimeti. Is this law a content-based restriction? That is, you only apply this law if there's pornographic material. It's reviewed with strict scrutiny. The Supreme Court upheld the law, but they didn't agree why. This one went 6-3. The majority by Justice Thomas found that intermediate scrutiny was appropriate. Justice Kagan in dissent said no, we should use strict scrutiny. Though curiously, Kagan seemed to hint that this law could actually survive strict scrutiny, that even though this is a very significant law, the state has an interest in protecting the children. That is the theme of last year, protecting children. Scrimeti, protect the children. Free Speech Coalition versus Paxton with the internet pornography, protect the kids. Okay. The next case is also about protecting the children. Mahmoud versus Taylor. This case comes from Montgomery County, Maryland, which is a very, very, very wealthy suburb of Washington, D.C. I could never afford to live there. The school board decided that we need to teach students at all levels, even kindergarten, about sexual orientation, gender identity. They started having books for young children about gay marriage, about questioning your gender identity, about transitioning and so on. You can look at these books. In fact, they actually, in the Supreme Court's opinion, they actually had basically a PDF of the book. You can actually look at these storybooks. It's sort of it's a good use of taxpayer resources, but they're in there. You can read them. What happened? Initially, the school allowed opt-outs, so parents could opt their kids out of this instruction. The problem was almost every parent wanted to opt out. They said, we don't want our kindergartners learning this material. And I, as a father of young kids, I can get why. So then Maryland changed the policy and said, okay, no one can opt out. And that led to litigation. Usually in religious liberty cases, the lead plaintiff is Christian, and that's been a sort of a criticism. But here the lead plaintiff was Mahmoud, who was from a Muslim family. Everyone objected to this law. Muslims, Jews, Christians, Buddhists, everyone. No one wanted their kids seeing this material. Okay? Two primary arguments were raised. The first was about due process. That is, again, parents have a right to direct the upbringing of their children, and parents should not have to force their kids to see this. Okay. The second was religion. Let's say a parent teaches at home that there's two sexes, male and female, and the kid goes to school and they're talking, no, it's the exact opposite. The argument goes that this law interferes with the parents' right to raise their children in their religious beliefs. The other side goes like this, that this is public school, there's a school board, they're elected. If you don't like the policy, lobby the school board, they'll change it. Don't go to court. There's a long history of people trying to opt their kids out of studies, for example, on biology and reproduction and even evolution. All right. So the court decides this case again in a 6-3 line. This was a hard left-right split. Alito had the majority. Sotomayor was in dissent. And the court rules in favor of the parents. And they found that this law substantially interferes with the ability of parents to raise their kids in the religion of their choice. Right? There's substantial interference. As a result, the Constitution demands an opt-out. You have to opt your kids out. There's a long history of opting your kids out of, we call it a family, what they used to call it, family resources. They have different euphemisms, like, learning about sex when you're like in the middle school, right? The difference was this is for kindergartners, and they said it was too much. You have to be able to opt out your kids. The dissent worried that this could lead to a regime where basically school boards lack power, and that now parents can basically opt their kids to have all different kinds of instructions. I did this event at this yesterday in Louisville, and the professor said, well, if you don't like this, don't go to public school. Of course, not everyone can afford to go to private school. That's kind of expensive in many states, especially in Maryland. I think the issue more importantly is even public schools are bound by the Constitution and the First Amendment, so they can't condition you going to public school and surrendering these rights. Okay. The next case was an amazing case that never went anywhere. Oklahoma statewide charter school board versus Drummond. Now they said, if you don't like the public school, go to a private school, go to a religious school. Well, Oklahoma tried that. Oklahoma created what was effectively a Catholic charter school where anyone in the state could attend this online Catholic charter school funded by the state. The Attorney General took the odd position that their own law was unconstitutional and refused to defend it. The Oklahoma Supreme Court said this violates the Free Exercise Clause by giving basically the power to run a school to a religious group. It comes to the Supreme Court. Supreme Court splits 4-4. What does that mean? No decision. The Oklahoma Supreme Court is affirmed. Why? Justice Barrett recused. Why did she recuse? We don't know. We can guess. She was very good friends with the law professor at Notre Dame who helped create this school, and maybe Barrett thought she couldn't be neutral. Well, as a result, the Oklahoma school does not exist. All right, let's move on to some Trump cases, Trump law, if you will, and a huge chunk of the court's docket is Trump related. Now, a lot of these cases arise not on the merits docket, right? It arises on the emergency docket. Now, what's the difference, right? Do you guys know the difference, right? So usually the court hears cases in a very deliberate fashion. Parties will file what's called a petition for writ of certiorari. That will sit around for maybe a month or so. The other side files a response. Maybe another month or so goes by. Goes to a conference maybe a month later. The court maybe grants the case. They then schedule oral arguments maybe 3 months later, and then decide it 5 to 6 months later. So in other words, from start to finish, it could be more than a year before the court decides cases. This is what we call the merits document, the merits docket. But then the court has another process, what's often called the emergency docket, or the shadow docket. I don't like this term, it sounds very shadowy. Or what Justice Kavanaugh calls the interim orders docket. Here, cases can be resolved very quickly. Here's how it usually goes. Trump issues an order. A couple hours later, a judge in Boston issues a temporary restraining order. I am not exaggerating. There have been judges in Boston in particular who have issued orders within hours of Trump's policy. They didn't even read the briefs. These briefs are 80, 90 pages long. They didn't even read the briefs. They just say, okay, temporary restraining order. National injunction, go. Trump, stop it. At that point, Trump then seeks an emergency appeal in the Court of Appeals, which invariably denies it, and he goes to the Supreme Court. And what they're asking is, please, Mr. Chief Justice, put on hold this lower court ruling to let us go ahead with our policy. Let it be challenged later in the normal course. Okay? An emergency docket case can be settled in the span of a week, or 2 weeks, or maybe a month. But what makes people very upset about this is that there's no oral argument. It's done sort of all on the briefs. Also, the court doesn't have time to sort of meet and discuss it. These are done only through memos. Moreover, there's not a full record, right? They don't have a lot of developments of what happened. And very often, the Supreme Court's deciding issues of law, important issues of law, on this fast pace. So there are a couple big categories of cases the court's already decided on the emergency docket. One of the earliest ones concerns the Alien Enemies Act. Josh, what the heck is the Alien Enemies Act? This is a law passed in the 1790s during the Adams administration. Yes, goes that far back. Which basically says if the president designates someone an alien enemy, they can be removed from the country. Shortly after Trump came to office, he designated a Venezuelan gang, Tren de Aragua, as an enemy of the United States. And the government designated, about 200 of these gang members, or alleged gang members, as subject to removal. This created this very strange litigation where judges in Washington held hearings over the weekend, basically in their bathrobes, to block the removal of aliens being detained in Texas who were being flown to El Salvador. And you had judges issuing orders saying, turn these planes around. Turn the planes around midair. Do you have enough fuel? I don't care. Turn the planes around, right? Where they're going to land, it doesn't matter. Turn these planes around. And the Supreme Court, in one of its earlier, probably not best moments, ruled in favor of the challengers and said, well, you know what? Let's just freeze things for a moment to see what's going on. But later, the court more or less said, courts in Washington, you don't have power over people in Texas. Stop. And the judges in Texas were allowed to keep the case. These cases are still sort of in limbo. We don't even know what the status is. The Fifth Circuit recently just granted en banc about the meaning of the Alien Enemies Act and whether there's an invasion. Okay. Another category of cases involves DOGE. We all know what DOGE is, right? The Department of Governmental Efficiency, one of the best acronyms like ever. One of DOGE's missions was cutting spending and firing people. Usually, if you work for the federal government and you're fired, you have a remedy. You have to go through what's called the Merit System Protections Board and use a civil process to challenge your removal. But after DOGE fired people, a lot of employees went to federal court. They started basically a TRO to block their removal. Lower court said, of course, we will take your case. And the Supreme Court said, no, 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 no. You can't do that. The way to challenge your firing is the civil service protections, not by going to court. Okay. The other aspect of DOGE is cutting funding. The government took actions to block foreign aid funding. For example, funding of AIDS research in Africa and other places. All right. Again, federal judges blocked Trump from doing this. The case goes to the Supreme Court. Initially, the court said, okay, yeah, you can block this when they came back. Another time, they said, no, no, no. The way you block funding is not by going to federal court. You have to follow what's called in the Court of Federal Claims, a very specific federal court to block funding. Okay. So where we are today is, if you want to challenge being fired, you can't go to federal court. If you want to challenge funding, you can't get a federal court temporary restraining order, right? If you want to challenge being detained, you can't go to a friendly judge in D.C. You have to go to a judge in where the person is being detained. Okay. Those are the law issues so far. But I think the biggest innovation on the shadow docket concerns birthright citizenship. On Trump's first day in office, he issues an order saying that the children of illegal aliens are not citizens, and they will not be granted any documentation from the government to show they're citizens. Within hours, federal judges in Seattle and Boston and everywhere else issued these nationwide injunctions. Now, what's a nationwide injunction? Usually an order, you learn this is civil procedure, binds the parties before the court. So you had the state of Washington sue here and the state of Massachusetts sue there, and all these lawsuits were filed. But Texas, where I live, never filed such a lawsuit. Kentucky, your Attorney General didn't file such a lawsuit. And the question is, why should a ruling from a judge in Washington apply to aliens born in Kentucky or Texas when your government didn't bring these lawsuits? And these lower court judges, well, we need national relief to affect our judgment. Because, imagine a mother's currently in Washington, she's pregnant, and then she travels to Texas and she's still pregnant. She'll be protected by the ruling. Let's make the ruling apply everywhere. The Trump administration made a very deliberate choice. They could have appealed the issue on the merits to ask whether the order itself was constitutional, but instead they chose a different path. They chose the path of saying, are these national injunctions valid? And they took this case to the Supreme Court. The Supreme Court, again, by vote of 6-3, again, left to right, ruled no more national injunctions. No more. Justice Barrett wrote the majority. Justice Sotomayor was in the dissent. Barrett explained that there's no tradition, no long-standing practice whereby federal courts can issue these rulings affecting parties beyond those who are present. I think Barrett had the history better. Sotomayor has a different history, but I think she made the more important point. What will happen if you can't issue national injunctions? Will it really be the case that every single litigant must go to court to vindicate their rights? She gave an example. Sotomayor said, what happens if the government decides to ban guns? And the president says, everyone surrender your firearms. Must every American then go to court and file a separate lawsuit to say, no, this violates the Second Amendment? There's a slight detour. If the government actually decided everyone to confiscate their guns, I think the remedy there would not be in the courts. You have an expression in Texas, we have it here, come and take it? Yeah. But I think the Sotomayor report stands, right? Can it really be the case that you need to file all these lawsuits? So you might think that after the decision, a case called Trump versus Casa, that the birthright citizenship case would finish. But no, almost immediately after this court decided this case, judges pivoted. Instead of issuing national injunctions, they used class actions. Did you all learn in civic procedure, Rule 23, and class action certifications? Does this sound even a little familiar? Okay. So you always get those, postcards in the mail. Ticketmaster charge you too much money. You can get like a 95-cent refund on a ticket. You see these, right? You have to opt into a class. And what's a class? A class when you pool together all the people who are affected by some action. They have a common interest. They have a common remedy. They can be represented by a single lawyer or group of lawyers. And the court issues a judgment, and that settles the matter definitively. That way, Ticketmaster is not sued in 100 different courts, right? There's one court that sort of settles, one ring to rule them all, right? One court to settle them all. So almost immediately, judges are issuing classes. But who's in the class? Every pregnant mother is in the country legally, all of them. You all protected. So they basically created a national injunction by another name. Now the case goes back to the Supreme Court, not on the class action issue, but on the merits. And the court will decide at some point this year whether Trump's order is constitutional. If the court finds that Trump's order is unconstitutional, then the remedy doesn't matter. The order can't be enforced at all. I think Trump's probably going to lose this one, maybe even 7-2 or 8-1, but we'll at least have clarity on the national injunction issue. Okay, let me just talk a bit about this term coming up. This term will be one for the ages. I'm sure I say that every year, but I really mean it this year. I promise I mean this. There are some issues that are, specific to Trump, right? That kind of just popped up in, Trump. But there are other issues that are long-standing. One of those long-standing issues, the president's power to remove. There was a case decided in the 1930s called Humphrey's Executive versus FTC, right? Congress creates these so-called independent agencies, these scare quotes, independent agencies. What are these independent agencies? Congress says the president can only fire these commissioners for cause, as if they engage in some sort of malfeasance or neglect or abuse of office or something else. For almost 100 years, conservatives have said this is unconstitutional. The president has this removal power which can't be constrained. President after president has said, this is bad, this is bad, this is bad. Trump's the first one to do something about it. He fires the member of the Federal Trade Commission. Her name is Slaughter. What a perfect name. He fired Slaughter, right? And he said, I am trying to overrule Humphrey's executive. The court, in an emergency docket ruling basis, said, yes, Trump, you can fire him. Or her, I'm sorry, fire her. So the case now goes to the court in the merits. Should they overrule Humphrey's executive? Big deal, right? This is not just about Trump. This is about Reagan, about Bush, about every president. And I think Trump's going to win this one. This might be the most important separation of powers case in decades. Another big structural case involves the Voting Rights Act, the VRA. The Voting Rights Act was passed in 1964. Was this law that, I'm going to describe it carefully, prohibits use of race in election law, broadly speaking. This law has been interpreted also to apply to the drawing of maps. How are congressional maps drawn? And the law has been interpreted to basically say you need to create districts where minority groups can come together and vote for the candidate of their choice, which is premise the idea that people who look alike vote alike. I'm grossly summarizing. The upshot of this law is it creates Democratic districts, right? There's no way around it. Every time this law is applied, it's going to be in the South against a Republican legislature who says that there are not enough Democratic districts for black and Hispanic voters. That's the laws enforced. You don't have to show intent to discriminate. It's just if you dilute the votes of black or Hispanic people too much, you get one of these districts created. The Supreme Court is now granting review and saying, is this even constitutional? If we are colorblind, how are we doing something, those things to say benefit a particular race? I think the court's likely to scale back the Voting Rights Act significantly. And again, this could create somewhere between 5 and 15 Republican seats in the next election. There are that many seats that are drawn precisely because of the VRA. Okay? Another big issue coming up this year concerns, again, transgender athletics, right? Can a state exclude or require transgender athletes to participate in female sports? This case, I think, would be pretty significant. All right. I think I've been talking enough. 37 minutes in. Let me pause for questions. Maybe I'll fill in some more details later. So thank you all so much.
So for the case on the Voting Rights Amendment and talking about how that would potentially, it would lead to sort of significant redistricting, how soon could that occur? Like, would that even potentially occur by November next year? So for like the midterms?
It's a really good question. In other words, if the court rules on the Voting Rights Act, how quickly can the maps be redrawn? So just look at the timing. This will probably be decided by June of 26, right? The midterms in November of 26. I think it's unlikely that you could have the decision and redraw the maps that quickly. In most states, at least in Texas, primaries are held well before June. In our case, primaries are held in March or April. So by the time you get to June, July, August, you're going to have a candidate for each district. It's hard to redraw the maps. This will almost certainly affect the 2030 congressional elections. It's just something to keep in mind as well. When you affect the maps, you also affect electoral votes as well, should the election ever go to the House. So this has consequences downstream for many years to come. Okay, what other questions we have? Yes, sir.
You didn't mention it, but I've been reading about a case the Supreme Court made hearing related to conversion therapy out of Colorado.
Yeah.
Can you distinguish that from the Cervetti case?
Sure. Yeah, this was actually just argued yesterday, actually, at the Supreme Court. The state of, which state was it? Colorado. Colorado passed a ban on what's called conversion therapy. And this is two different sorts of things. Conversion therapy for gender identity and sexual orientation. There's a long-standing, not long-standing, but there's a long and sort of very sad tradition of treatment where you try to convert someone to not be gay anymore. And that would often involve electroshock therapy and other types of fairly invasive treatments. And there's a lot of studies showing that that sort of treatment doesn't work. Okay. There's also a far shorter history of what we call gender-affirming care treatment. That is a minor goes to a therapist and says, I'm having some doubts about my gender identity. And even though I'm biologically male, I think I might want to be female. Under the Colorado law, a doctor can say, yes, you should be female, let me help you affirm that, let me help you get there. A doctor cannot say, well, maybe you should just wait and see how things develop and maybe you should be content in your own body. What the Colorado law did is says you cannot give advice to oppose gender-affirming care, but you can give advice to support it. There's far less science in settled medicine about whether the gender identity conversion therapy is harmful. Colorado deemed both the sexual orientation and gender identity to be both be harmful. The court argued this case just yesterday. I haven't read the transcript yet. I will shortly. And the court seemed to be leaning that the law in Colorado is unconstitutional. But just pause on this one for a minute. If Colorado can say you can't talk someone out of gender conversion, Could Texas say the opposite, the mirror? Could Texas say, you cannot counsel minors to having it? And that relates back to Scrimeti. In other words, if the state can ban transgender medicine, can they also ban therapy to support that medicine? The answer is probably yes. So I don't know what happens with the Colorado law, but I think that this will be probably an issue where Colorado loses, at least in some part. Good question. What questions we have? Yes, sir?
We had Bruin, which didn't get chance to protect for the second amendment, and then Rahimi, which kind of fumbled how it's applied. And the court seems to be denying cert on all other types of firearm regulations. Do you see that changing anytime soon?
Yeah, so I think I was here last year talking about Bruin. Did you ask me a question last year?
I did.
Yeah, you look familiar. I remember you all. The Second Amendment. The Second Amendment's had a weird run, right? Where for more than 100 years it really had no juice. Didn't really do anything at the Supreme Court. And then we had Heller in 2008 saying, yes, you have this right. And McDonald 2 years later saying, yes, you have a right that applies to the states. And then nothing for 13 years. And then we got Bruin 2022, which said, yes, you have the right to carry. But then Rahimi said, well, not if you're too dangerous, right? Not if you did something bad. And so the court has not given a lot of clarity about where they really want to go with the Second Amendment. Just last week, the court granted a case of Hawaii. And this is kind of a curious case. Hawaii had a law that said guns are banned everywhere unless you post a sign saying guns are permitted. So if you don't post that sign, guns are basically banned everywhere. The Supreme Court grants review in that case. So it's kind of a weird gun/property case. But they've denied review on everything else. They've denied review on whether an AR-15 is protected by the Second Amendment. They've denied reviews on silencer cases. They've denied review on capacity of magazines. I don't think there's a majority that knows what they want to do with guns. It's like, okay, we'll let you carry, that's fine. But basically, these states have made it impossible to carry anywhere. If you can't carry consistently, you can leave the gun at home. You don't want to be trapped. So I think the court doesn't know. I'm not sure where Barrett is in this issue either. Good question. What are the questions we have? Questions. Going once? Going twice?
Well, if there's no further questions, then everyone please join me in thanking our speakers.
Thank you.
Please mark the calendars for our next event on October 29th. We're hosting Ilya Shapiro, so that.
Oh, my good friend Ilya. I'll tell him I said hello.